Great. The clerk can call the court in session.
The Court of Appeals for the 8th District of Texas is now in session.
Welcome and good morning. We're here on initially the case from El Paso County, Mario Ernesto Martell versus the state of Texas. Mr. Martell is represented by the Assistant Public Defender, Octavio Dominguez. Mr. Dominguez, can you hear us?
Yes, Your Honor.
Great. And the state of Texas by its Assistant District Attorney, Tom Darnold. Can you hear me, Mr. Darnold?
Yes, Your Honor. The state is ready.
Fine. Okay, with that said, Mr. Martell, you may proceed any time that you are ready.
Thank you, Your Honor. May it please the court, honorable justices, opposing counsel, members of the public, good morning. This appeal arises out of an erroneous ruling by the trial court following a contested revocation and adjudication. And so we present the following 2 points of error for this court's consideration. First, the trial court abused its discretion when it failed to properly consider the affirmative defense asserted by my client, Mr. Martell, of due diligence. And second, even if the court did so consider that defense, that the trial court's ruling was still both legally insufficient and factually insufficient. And so before I jump into the issues, Your Honors, I want to do some quick housekeeping. It's undisputed that the trial court had jurisdiction in this matter. Both the motion to adjudicate and the capias were timely filed and timely issued. The state at that revocation hearing did carry its burden by showing that Mr. Martell failed to report during the listed months, and they carried that burden of preponderance of evidence. I believe it's also undisputed and uncontested that the defense that Mr. Martell was entitled to invoke the affirmative defense of due diligence. And so I don't think those things are in dispute. Also, I believe the state in its brief, it's correct that we are looking at this case under 42A.109. I believe the appellant brief did make reference to 756, but we are under 109. And finally, I believe that most of the facts ascertained at that revocation hearing were uncontroverted for the most part and undisputed. And so with that—
Okay. If I could interrupt you for a minute.
Yes, Your Honor.
Before we move off that point, your client pled guilty in 1999, as I understand it, and then almost immediately did not start reporting. And then the state initiated the paperwork that it does to initiate the revocation. The statutory defense, I thought, was put into law in 2003. And so why wouldn't we be talking about the common law defense of due diligence, since that was what was in effect at the time that the revocation proceedings were started?
Yes, Your Honor, a good question. It's because the statute went into immediate effect, and it applied for hearings that occurred after the statute was enacted. And so I don't think it's in doubt that we're looking at the statute, because the hearing on the matter didn't occur until 2018. And so that's what we're looking at. Common law does not apply, because even though he originally pled while that common law was in place, we look to the statute, because by the terms of the statute, it went into immediate effect and applied to hearings that were conducted after. And just to correct a little bit of the fact, I believe the testimony at the revocation hearing indicated that Mr. Martell had reported on 2 occasions before he stopped reporting.
That's true.
Okay, so as to the first issue, Your Honor, this issue is an abuse of discretion issue, and again, it relates to the trial court failing to properly consider the defense asserted the preponderance of the evidence the due diligence defense. And I do want to focus in this court on the exact language that the court used, because our argument is not that the judge didn't state that she considered it, because she explicitly said that she considered due diligence. It's rather that the explanation that she gave for the ruling kind of contradicts that statement. And so the trial court statement, and I quote, was, "So I want to make sure that I put it on the record that I did consider the arguments on the due diligence in chambers. I did tell both sides that the fact that Mr. Martell had been given permission to reside in Mexico that I didn't feel that it was in the interest of justice to allow him to use that also as a reason to bring up the due diligence was not done like it would have been done if he had been residing here in El Paso County. And so this issue and this argument is very simple for us. We don't believe that that analysis took any of the considerations of due diligence into account. And so we don't believe that there was a true consideration of the defense that was asserted by my client, Mr. Martell. And that's because, again, the trial court simply seemed to say that simply because it wouldn't be in the interest of justice in order to allow him to plead that affirmative defense, that the trial court wasn't going to credit that defense to Mr. Martell. And so there's no indication in that ruling, whether or not the trial court determined that Mr. Martell had met his burden, but because of this other stuff, that it outweighed giving him that. And so that's why our argument on this first issue relates simply to that. And it's very closely related to our second issue, to the legal insufficiency of the second issue, because we're kind of looking at similar but different reasons why there was an abuse of discretion. So our argument under the first issue is that there was an abuse of discretion because the trial court didn't consider it at all. Whereas our argument under the first part of the second issue, the legal insufficiency, is that the trial court did consider the affirmative defense, but misapplied the law to the facts. And so that's why I want to talk about the statute at this point, 42A 109, because the statute, it's very clear and explicit on its face that it requires at the bare minimum that an attempt be made for in-person contact. And there's nothing ambiguous about the language used in the statute. Just a plain reading of that statute makes it a clear obligation on the part of the state to show that there was an attempt made at in-person contact, or rather, I should say in the statute, it states that that attempt should be reflected in the files of the department serving the county in which the order of deferred adjudication community supervision was entered. And as I mentioned, most of the facts in this case are completely undisputed and uncontroverted. And a large reason for that is because the original supervisory officer was not called to testify in that case. Mr. Carlos Estrello, who was the probation officer at the time, in 1999, was no longer in the probation office. And so the state, during the contested revocation, called Mr. Adrian Aguirre, who is also a probation officer, and he testified purely from the file. And so he didn't testify from any personal knowledge. It was just from the file. And the file simply reflected that, that after Mr. Martell had reported on the first two occasions in the first 2 months and had made 3 payments, that at that point in time, there's no other recorded contact with Mr. Martell. 2 letters were sent in January and February, I believe, following his failure to appear in December and January, and 1 phone call was placed in February. And so there is nothing in the record to indicate that an in-person attempt was ever made by anyone in the probation department.
And counsel, if I may, so, and I understand, and just if you know, you can answer the question. There's no indication as to whether or not there was any type of extradition process or attempt, because I understand that under the laws of the United States and the state of Texas, we do have that ability. And by that, I mean the law enforcement has the ability to work with the authorities in Mexico to retrieve and recover certain individuals. Is that not correct?
And that's correct, Your Honor. And this brings us back to the state's argument in their brief as to why they should be excused from that obligation. And it's because they believe that the fact that Mr. Martell had been allowed without objection to reside in Ciudad Juarez, that in and of itself should excuse them from their obligation. And they cite to Ohio v. Robert for the proposition that they shouldn't, that the law doesn't require a futile act. But I want to go back to that case and just read the rest of that quote, Your Honors, because the rest of that, and this did deal with witness availability, but the rest of that dealt with the state having to show a good faith effort that it was futile. They couldn't just simply declare that it's futile. They have to actually show in the course of that process that it was futile. And the full quote from Ohio v. Robert was that, thus, if no possibility of procuring the witness exists, good faith demands nothing of the prosecution. But if there is a possibility, albeit remote, that affirmative measures might produce the declarant, obligation of good faith may demand their effectuation. And so, yes, Your Honor, I do believe that there were processes available to both law enforcement and the probation department in order to effectuate and show this good faith. Because number one, this was back in 2003. And between 1999 and 2003 was when the original probation term of 4 years was supposed to run. And so back in 1999, 2000, and even today, even with the COVID crisis that's hitting us right now, I can walk across the bridge as a US citizen and I can go anywhere in Mexico and I can knock on a door. And so there's nothing.
Yeah, but you can't perform a judicial act. Ask any court reporter, they would tell you they do not go over and take depositions in Mexico because I think it's deemed to be illegal there. I mean, there would have to be some process where you would work through the authorities to actually contact this individual if you're performing some official act like an arrest or giving him some sort of notice. Correct?
Correct. Yeah, yes, Justice, you're absolutely correct. And I think that leads to Justice Rodriguez's point in that there are processes in place. There are agreements in place between our government and the Mexican government. And in fact, the district attorney's office has an entire unit devoted to just processing these types of cases. And so I would say at a bare minimum, in order to, because remember, the statute only requires an attempt. It doesn't actually require that the contact be made in person. It requires an attempt. And I would say good faith would require that at the bare minimum, they send out a request or they show that some work was done by the unit that the district attorney has in order to process these things. I mean, every single day we reside here on the border. This is an issue that every single court in El Paso sees and deals with when they're weighing whether or not to allow this condition of allowing probationers to reside in Mexico. And so trial courts are very much aware that that there are means of being able to make an attempt of getting back in contact with these individuals who aren't necessarily residing in the United States. And so I would argue that yes, that good faith in this situation would require at the bare minimum an attempt and a failure. That would show that a good faith attempt was done. And
So let me,
yes, Justice.
Judge Palafox.
Okay, sorry. The burden of proof, though, lies on the defendant, Mr. Martell, basically due to the shift that occurred with the enactment of the statute. And so it sounds though that he's put into a position of maybe having then to prove this negative, that these extradition processes were not attempted, or how is it that this record in itself carries the burden of proof that's shouldered by Mr. Martell?
Good question, Justice. I would argue that we carried our burden of proof when we showed that no attempt was made to effectuate an in-person contact. That's our obligation. That's the duty under the statute, and there's nothing ambiguous about that statute. Now, if the state wants to be excused from that obligation, then I would argue that it's their burden to show that it's truly futile, and it would be their burden to show that a good faith effort was done. And even if it was our burden to show, again, there's no record in the probation file that they made that attempt. And so I would argue that that is the whole of the record, and it represents all of the attempts that were made, all of the attempted contacts that were made. And so I would say that the record does reflect that we've met that burden if it was our burden to meet in the first place. And staying on this subject, I would also argue that it's that individuals that are placed on probation, by and large, trial courts, or appellate courts, I should say, when they've analyzed this issue, they've looked at it through the framework of contract in the terms of that these are terms and conditions agreed upon between the probationer and the trial court. Because again, probation is not a privilege. It's something that in exchange for each side receives a benefit, consideration. And in this situation, the trial court could have easily, number one, not granted that condition, not allowed him to live in Ciudad Juarez, and that would have done away with this entire situation completely. But in the second place, the trial court could, or with the objection of the district attorney, could have placed a waiver of the affirmative defense of due diligence. They could have conditioned it on that. They could have conditioned his right to live in Ciudad Juarez on him waiving that defense in a future revocation hearing. And none of that was ever done. The record doesn't reflect that there was ever an objection made, and the record doesn't reflect that there was ever any worry by the trial court in regards to following up possibly in the future in regards to how that supervision would be kept in place. And again, the probation department was also a party to this, and where they could have flagged this for the trial court, but nothing was said, nothing was done. At the end of the day, Mr. Martell was allowed to reside in Ciudad Juarez, and no one ever made an attempt to go to his home or to make contact with him in person. And I want to transition here a little bit into now the factual analysis, because the only way we get to the factual analysis is if this court says, okay, then you know what, the state was not obligated, despite the plain meaning of the language in the statute, the state was not obligated to make an in-person contact. So now we actually look at what they did, and let's look at what they did. And so they sent 2 letters, no return receipt, to the address that Mr. Martell and Mr. Martell did give a home address and a place of employment. It was the same address. And so they mailed 2 letters in back-to-back months in January and February of 2000. There's no indication if those mailings were ever received. And they placed 1 phone call in February where an individual by the name of Maribel, who identified herself as a friend of the family, answered the phone, but there's no other details in regards to what that call, what the content of that call was. You know, did they leave a message? Did Maribel say that she would get in contact with them? Did they ask Maribel if Mr. Martell was still residing in there? We don't know. And so I would argue, and this is where this is why we cited Bauckham, which yes was a precodification case, but we cited it for this purpose to show the court and say this is the way the courts have analyzed when they've actually gotten to the part where the court is using its discretion to determine whether or not sufficient due diligence was done by the government. Let's look at what they did. And clearly, I would argue that within the time period that we're looking at, 2 letters and 1 phone call, none of which ever reached, or none of which there's any indication ever reached the probationer, is completely insufficient. And so I think one of the factors that the court has to look at, that the trial court should have looked at, is the duration in time while these actions were taken, because that's what the Bauckham case talks about. And that's why I cited the concurrence in Bauckham, which I didn't mean to represent as the holding in that case. I cited it for the purpose of persuasive analysis in terms of how to look at this totality of the circumstance issue. And when you're looking at a situation, when you're looking at a case where an individual is placed on 4 years probation, and the only contacts are made within the first 4 months of that probation, and that the violation the violation notice isn't even filed until 8 months later. So there's another 4 or 5 months there between the last attempted contact and when the violation notice is filed. And then there's another 18 months before the motion to adjudicate is even filed. And yes, yes,
If I may, I want to make sure that I understand your argument.
Yes,
If
sir.
the statute says that the state has to make some sort of attempt at in-person contact, all of these issues about whether they sent one letter or two, or whether they made one phone call or 50 phone calls is kind of irrelevant, isn't it? Isn't the only question really before us whether the statute requires an in-person contact and whether that was met, or whether that's somehow legally excused because the individual is in Mexico?
No, you're absolutely correct, Your Honor. And that's what the weak case out of Texarkana that we cited in our brief stands for, because in that analysis, the court basically said, this is all the actions that they did. But on the very narrow issue of whether an attempt was made at in-person contact, there's no evidence in the record. And so the weak case did exactly what you're suggesting, Justice, which was they said all of this other effort that was made is completely irrelevant because they never even attempted the in-person contact. And so this argument that I'm putting forward before the court is my argument if the court excuses that obligation and says because of legal or factual futility, they didn't have to meet that obligation. Because at that point in time, then you would have to look at whether given the facts, given the things that they did do, whether that was sufficient. And I want to jump back to that subject, Justice Alley. As I said, I don't think there's anything ambiguous about the statute, but if there is ambiguity in regards to whether that in-person contact needs to be attempted, then I would suggest that an extra textual analysis would reveal that in-person contact was very much in the forefront of the legislators' minds when they drafted and enacted this statute. Because if you look at the legislative history, you'll see that that initially this was HB 1634. When it was initially introduced, the only requirements that they had for due diligence were actually a phone call or a telephone in the listed or a telephone to the listed number within 45 days, either before the motion to adjudicate was filed or 45 days after the motion to adjudicate was filed. By the time
is there anything in the legislative history that suggests the legislature understood that a lot of these probations were being granted kind of along the border, and that it may have been kind of a common practice for people to go live across the border during their period of probation? I'm just curious as to whether that was ever discussed.
No, Your Honor. I mean, I think being here in El Paso, we face unique issues in terms of law enforcement, and I don't think that was something that was taken into consideration. However, issues of cross-jurisdictional have, and I want to draw this court's attention to a case that this court ruled on in 1997 called Sessions v. State 939 Southwest 2nd 796. And that's out of this court, the 8th Court of Appeals. And yes, it was pre-codification, but this court was dealing with a case that involved a probationer that resided out of state. But the court similarly analyzed the issue and held that, and I'm going to quote from the opinion here, the fact that a probationer leaves the jurisdiction does not excuse the state's duty to exercise diligence in apprehending the probationer. I would argue that that's still good law, that should, at the very bare minimum, should be persuasive towards this court in regards to the cross-jurisdictional issues. And so, yes, Your Honor, our position here is that the statute sets out the bare minimum that has to be shown by the probation department before the court can engage in using its discretion to determine whether due diligence was effectuated. Without an attempt being made, without that floor being met, you don't even get into that analysis as shown by Wheat. And I think the record here is it's undisputed and pretty clear that no attempt was ever made. And so we would be asking, Your Honors, that the court reverse and render in this situation, because again, I don't believe that there's any Any issues of fact in question, I believe that this is a straight application of the law to the facts. And so at this time, Your Honors, we would ask for that. Thank you.
Thank you, counsel.
I'm open to any questions. Thank you.
Mr. Darnold.
Thank you, Your Honor. May it please the court, Mr. Dominguez. I think this court seems to be very well-versed in the factual context of this case. So I'm going to skip that and go straight to the defendant's specific complaints. His first complaint, the specific complaint, seems to be that he's complaining that the trial court erred as a matter of law in ruling that the affirmative defense just simply wasn't available to the defendant because he was permitted to live and work in Mexico. But I think a fair reading of the context of the trial court's comments shows that that's not what the court ruled. She didn't rule as a matter of law that this defense simply wasn't available because he was living and working in Mexico. She just considered the fact that he was living in Mexico, he was permitted to live in Mexico and permitted to work in Mexico. She considered that fact as just one of the factors in the determination of whether the required due diligence was shown. So instead of a legal question, it was more of a factual and a discretionary call, an application of those facts to the due diligence law. And that kind of ruling is within the trial court's discretion as a factual determination. So I think when the court says, and I'm quoting volume 4 at page 5 of the record, the trial court stated, "So I want to make sure that I put on the record that I did consider the arguments on the due diligence, So I think the court's comments in the context of the entire record show that it was not, she did not rule as a matter of law that he just could not raise the due diligence issue. She just ruled as a matter within her discretion that he had failed in his burden of proving due diligence based in.
Mr. Darnold, let me refresh my memory. Is the burden on the defendant to prove an affirmative defense in this context? What is his burden, I guess?
Yes, the defendant's burden under 42A 109, I believe the statute says it's an affirmative defense to revocation beyond the period of supervision. It's an affirmative defense if no law enforcement officer attempts to contact the defendant at his last known address.
I guess I was speaking more about, is it by a preponderance? I'm thinking it's a preponderance, right?
Yes, that's the general burden of proof in an affirmative defense.
That's what I was thinking. Okay, yeah. No, I have the statute in front of me. I just couldn't remember. So it's by a preponderance, right?
Yes, Your Honor.
Okay.
So you have the probation file that says we tried to contact the man this way or this way, and neither of those two ways were in person. And so, I mean, I guess I'm trying to understand why he didn't discharge his burden of proof there. I mean, you can't just speculate to say that somebody went over and knocked on his door if there's no evidence of that.
That's correct, Your Honor. And the state is not going to try to say there was some evidence of an in-person contact. There may have been, I don't know, but there was no evidence. That we didn't put on any evidence, even though it was not our burden. We certainly did not put on any evidence that they tried any in-person contact to try to go knock on his door.
And you could infer, I mean, it's a fair inference if the file says we tried the following 3 ways to contact him, that they didn't try the 4th way, right? I mean, that's a fair inference, isn't it?
I think that is a fair inference, Your Honor, especially when the probation officer who testified, who was not the probation officer at the time, he said, this is how we tried to contact this person. So I think I would agree with the court that it is a fair inference that there was no attempt at in-person contact in Mexico. If I want to backtrack just a moment to his first specific claim in his brief on the sufficiency issue, He claims, because his sufficiency claim is really twofold. The first one is that the evidence was insufficient to reject the affirmative defense because there was no evidence of any post-capias attempts to contact him, alleging that there's a requirement that the attempt to contact him occur after the capias issues. And I think that law has been settled since early 2000s, that there is no requirement of post-capias attempts to contact the defendant. Any attempts that were made before the capias issued can be considered by the trial court and the reviewing courts in determining the due diligence issue and if that burden was met. So I think,
just on that one point that you're making there, Mr. Darnold, then since the statute was enacted in 2003 and later reenacted, I guess I would expect that we're supposed to give it a plain reading of the statutory text. So how do you integrate the idea that you said there's prior authority that should be considered?
the Baucom case that's cited in the briefs, it is a pre-statute case, which expressly rejects the notion that pre-capias attempts can't be considered in the due diligence analysis. I think even though I think that case law carries forward into the new statute, and the post statute case, the most recent one from the Court of Criminal Appeals, the Garcia case that's cited in the brief, it interpreting the due diligence statute, it makes no mention whatsoever of any kind of requirement of post capias attempts at contact. It just analyzes what attempts were made to determine whether it was sufficient. And so there's been no reformatting of the pre and post capias attempts since the statute was enacted. And if the Garcia case, if they had intended to reimpose a requirement of post capias attempts, they certainly could have done that, but they did not. So I think that first part of a sufficiency claim should be overruled.
Well, so looking at the actual text of the statute, in the third line of it, it uses the phrase for that alleged violation. Do you see that, or should I give you more context?
Yeah, for that alleged violation.
It's an affirmative defense to revocation for an alleged violation. Okay, I think I see it, Your Honor.
So I'm looking at just that wording, for that alleged violation, that there's no in-person contact. So I'm just like, for that alleged violation, to me sounded a bit as though the state is already in a position to say that the allegations being made that there's a failure to report, and now you need to make that in-person contact.
I don't read it that way, Your Honor. And based on the case law interpreting, let's go back to the Baucom case, which was a pre-statute one, pre-statute case. The rationale for rejecting the requirement for post-capias attempts would be the same, whether we're talking about a statutory due diligence defense or a common law due diligence issue where the burden was on the state. So the requirement of pre and post capias, pre or post capias attempts would be the same, in that if the officers were actively or had actively looked for the guy to no avail, the rationale is there's no requirement that they repeat those attempts that have already been shown to be fruitless. It's a waste of the government's time and money to require them to redo what they've already done. And I think that under that rationale, which was the basis for rejecting that post capias requirement, that rationale would carry forward even under the language of this new statute. They try to
Right. Well, so I guess in this particular scenario where we look at the facts, let's just assume when they sent those 2 letters, what if they had that same month made arrangements somehow through authorities in Juarez to have an in-person contact?
I think
That even though at that point you don't even have an alleged violation, or do we just look at it as part of the entire process?
I think we look at it as part of the entire process. And on, if I can get in more detail on that note, Your Honor, even if they had contacted some authorities in Juarez to go try to contact him in person, that still would not satisfy the plain language of Article 42A 109. It requires an in-person attempt by a probation officer, a peace officer, or some other officer with the power of arrest under a Texas warrant. And no Juarez police officer or other agency or other officer would satisfy any of those requirements.
Oh, let me stop you there, just so I make sure I understand. I mean, I get, so there's 3 persons who could make this in-person contact. It could be a supervision officer, and I think we could agree we don't want our probation officers going across the border. It could be a peace officer, and I think we could agree that we don't want our policemen walking across the border doing something like that. But then it has this catch-all that says, other officer with the power of arrest under a warrant issued by a judge. So we've had this treaty with Mexico since the 1980s, where if we want somebody extradited, we can present to their government, I guess whatever documents that we have documenting the crime, and possession of narcotics is one of the listed crimes under that treaty. And then the Mexican authorities would arrest that person and deliver them to us at the border. So why wouldn't the Mexican officer taking custody of the person pursuant to this extradition treaty, why couldn't we consider them one of the other officers with the power of arrest? Because they do have the power of arrest in Mexico, and they're doing it pursuant to a warrant that we've initiated and then started through this process.
And I'm just going to interject, and I understand that they detain the individual and they bring them to the border and there's an exchange. And at that point, law enforcement officers from the United States properly makes the formal arrest here in the United States at the border when the Mexican authorities surrender that particular individual. And so I think that statute could be met under that scenario as well.
Okay, yeah, I'm glad Your Honor's asked that, because that gets to who the duty of due diligence falls on. The duty of due diligence under the statute falls on the local law enforcement officers, the probation officer or an officer. So the due diligence requirement is placed on the officers to try to timely execute the arrest warrant. The extradition proceedings, the law enforcement officers are really the local law enforcement officers are kind of out of that proceeding. That is a proceeding initiated by the state, the prosecutors, the DA's office. The due diligence requirement doesn't require the prosecutors to do anything. It doesn't require the prosecutors to try to go get the guy or to try to initiate any proceedings to get him. The due diligence requirement falls on the duty of the officers on the ground, the probation or police officers looking for the guy, or who should be looking for the guy, to try to execute the
Can you
case.
guys hear me?
Yes, you're
Sorry. Oh, sorry, you guys froze on me for a bit.
Oh.
It's unlocked now.
Were you able to hear me, Your Honor?
I'm sorry, I didn't.
Okay, well, simply I was just saying that the due diligence requirement doesn't require the prosecutors to initiate any proceedings to get the guy from Mexico. The due diligence requirement is expressly on the officers, not the prosecutors. So because of that, yes, if the prosecuting office initiates extradition proceedings and it goes through all the proper channels and they get the proper paperwork into Mexico, then yes, a Mexican law enforcement officer could take custody or detain this person and bring him to us. But that's not what the statute even purports to require. It doesn't purport to require the prosecutor to do anything. It requires the probation officer or the local law enforcement to try to execute the capias. So the fact that there could be a Mexican law enforcement officer who could have the power of arrest if some intervening circumstance, the initiation of extradition proceedings were initiated, that doesn't mean that a Mexican law enforcement officer would have the power of arrest as contemplated by this statute, because that would require this intervening intervention by the prosecutor's office, which is not contemplated in the statute.
I guess whoops, sorry, go ahead.
I just want to clarify or contextualize this a little bit, Mr. Donald, if we could. And as a former prosecutor, it's been my experience that a number of the trial courts, not just Criminal District Court number 1, when they had foreign nationals in front of them, placed them on what they called foreign national probation, in which those individuals who may or may not have had permission to be in the United States were placed on probation, but because some of them, not all of them, were in the process of being deported, were given permission to reside in Mexico because they didn't have permission to reside in the United States. And so the expectation was they were going to return to Mexico, but everyone understood that they did not have the capacity to report in person because they didn't have permission to cross. And so kind of built into that for national probation for undocumented individuals, which may or may not have any relevance here, but were never able to complete the terms of their probation, and everyone understood that.
Correct, Your Honor. And but okay, first of all, that situation doesn't apply at all here. This defendant is a United States citizen. He was at the time of the guilty plea. He just, for whatever reason, and I don't know what that is, he wanted to reside and work in Mexico. So he was a U.S. citizen and could freely cross to report as required. And in the foreign national probations, generally there's no requirement that they come back and report. That's not one of the terms of their probation.
Okay, thank you for clarifying that. I appreciate it.
So the big problem here for the state is the plain language of the due diligence statute. It says it's an affirmative defense if there's no attempt at in-person contact. That's the plain language of the statute. And normally, as this court is well aware, the plain language of the statute controls. However, if the plain language of the statute would lead to an absurd result that the legislature could not have intended, then you can look at the legislative, what was the legislative intent, and look at extra textual factors such as the legislative history to see just what the legislature intended when they enacted the statute. And we're not writing on a clean slate in that regard, because the Garcia case that's cited in the brief from the Court of Criminal Appeals, they examined the legislative history of the due diligence statute. And they concluded that the overriding intent of the legislature was to, I'll simplify this, just to make it easier for the state to revoke people who were not found within the probationary period. The language it was so as to facilitate greater leeway in revoking these defendants who eluded or otherwise avoided arrest during the period of their probation. And just as the trial court recognized below, the statute was intended not to reward defendants who, however, who evaded or avoided being arrested. It's not just for those who actively evade police and hide, but who in any way avoid being arrested. The statute was intended to keep those defendants from obtaining a benefit.
Counsel, I know at least the Texas Supreme Court is very clear that we look for intent from the words of the statute, and that we don't look to legislative intent unless there are ambiguities in the statute itself. Is it any different at the Court of Criminal Appeals? Don't we interpret statutes the same way?
It's very slightly different. The ambiguity language is in there, but in the Garcia case, and there's many cases on legislative intent in criminal or statutory construction in criminal cases. Not only are the courts allowed to look at legislative history if there's an ambiguity in the language of the statute, but also if the plain language of the statute would lead to absurd results that the legislature could not have intended. So there's that additional situation where courts are permitted to look at the legislative history. And this is one of those cases that would lead to an absurd result that the legislature could not have intended. And back to your question earlier, Chief Justice Alley, I didn't see anything in the legislative history where it was even contemplated about this situation where a probationer was permitted to reside in Mexico. And
so let me understand though your argument. Are you asking us to move beyond the plain text of this statute in a case specific way, only because this particular defendant is unique, but otherwise we would limit ourselves to the plain text?
Yes, that's exactly it, Your Honor.
And do we have that authority to do that for just, one particular defendant?
Yes, I mean, yes, because it's this court's interpretation of the statute, which in this case should not be limited to the plain language, because that plain language would lead to disparate rules. It would lead to two sets of rules. The normal probationer who is required to live and work in Texas would have a tougher time satisfying his burden of under the affirmative defense of showing no due diligence, because all the officer would have to do is go to his house and knock on the door. But sort of the converse of what the defendant argued the trial court did in this case, which is ruling that as a matter of law that the affirmative defense is not available to a defendant who lives in Mexico. The plain language of the statute would create a per se affirmative defense for defendants who were permitted to live in Mexico, because no officer could ever go try to make in-person contact.
So why wouldn't that just be handled in the terms and conditions then? At the time that the state is bargaining, this was a plea bargain case. Why not have the states integrate that into their side of the bargain, just to say, because you want to live in Juarez and the judge is very likely to approve that, that means you must also waive your affirmative defense.
Well, again, this is a very fact-specific case. And at the time of the guilty plea and when he was placed on probation, that affirmative defense didn't exist. So there was no reason for the defendant to waive the affirmative defense at that time.
But it existed by common law. And
But
the Garcia case mentions that it existed for over 40 years.
But it was not an affirmative defense. The burden, the diligence issue was an issue the state had to prove. The burden was on the state to prove what diligence they exercised in apprehending him. So the defense could raise the issue, but the burden was on the state. There was no affirmative defense. It was a defensive issue that the state was required to disprove. So at the time, there was no.
Before you run out of time here, why? I don't know if it's outside the record, so maybe it's up to you to answer this. But why does the state have an interest in 2018 in this situation?
This is not the crime of the century. Nobody's going to argue that. It's a question of law, Your Honor. The trial court, within her discretion, ruled that the defendant had failed to show his burden to show due diligence, or a lack of due diligence, and revoked or adjudicated his deferred adjudication and placed him on straight probation. The state believes that that ruling was well within the trial court's discretion based on the law and the interpretation of Article 42A 109. The state believes that the trial court was within its discretion to so rule, and so that ruling should be upheld. It wouldn't matter so much if this was a murder case, a drug case. It's a question and a matter of the trial court's discretion and the law as it applies to these facts. And the state always tries to make sure that the courts are following the law and that the court's rulings, if proper, are upheld. The trial court made that decision. It was within the court's discretion, and that ruling should be upheld.
Counselor, you're over time, but I do have one other question for you. Would the situation be any different if the probationer lived in, or we permitted him to live in New Mexico, or if this were a case in Texarkana, if we permitted him to live across the border in Arkansas, or if you were in Orange, Texas, that you permitted someone to live in Louisiana? Because presumably we don't want our probation officers, police officers doing things outside the border of the state of Texas in those situations, correct?
That's correct, but that situation would be different, Your Honor, because an officer in another state of the United States has the authority to arrest based on a Texas arrest warrant.
Okay, but
I was just going to say, normally, and Mr. Donald, correct me if I'm wrong. Some of those, if I remember correctly, aren't they transferred? Don't those can that probation be transferred to the other state, and then the other state monitors it?
A lot of times that is correct, Your Honor. Yeah, that the entire probation is transferred to New Mexico or Louisiana, and they take over the supervision. But even if not, if he was on probation in Texas and allowed to live in Las Cruces, if he violated his probation, the Texas judge could issue a warrant, a KPS or a warrant for his arrest, and a Las Cruces police officer could arrest the defendant based on that warrant without any intervening judicial proceedings or anything initiated by the prosecutor's office. After the arrest, then the interstate extradition procedures would kick in, but the actual arrest could be made by a Las Cruces police officer. So he would fall under the other officer with the authority to arrest under a warrant. So there would be, still could be a requirement of getting that Las Cruces officer to go look for the guy at his home in Las Cruces.
thank you, counsel.
Thank you. The state would ask that this conviction be affirmed. Thank you.
Mr. Dominguez, do you have any rebuttal?
Yes, I do, Your Honor. And just to clarify, I have 10 minutes.
Yes.
Is that correct, Your Honor? Thank you.
Yes. But you're not required to use it all.
Okay. I'll see what I can do. I just want to clear up some quick points. And I'm glad the court spent some time on Garcia, because I do want to talk about that case more at length. But I do want to clarify, it is not our position in this appeal that post-KPS efforts have to be shown. We absolutely agree with the state that not just the code, but Bauckham did away with that bright line completely. And so we don't mean to imply that post-KPS efforts have to be done as a bright line issue. Instead, we argue, and again, this is just if the court moves beyond the issue of the in-person attempt. Post-KPS efforts, we argue, still have to be looked at when, not as a matter of law, but they have to be looked at within the totality of the circumstances. And so I want to clarify that first part of the argument. Justice Palafox had a question about the text of 42A 109, specifically for that alleged violation. And I think I can clear that up. I believe, and I apologize, I don't have case law for this right now, but of course we can offer supplemental briefing on it. But for that alleged violation, courts, the way they've looked at it, it's in regards to the warrant being issued. And so the warrant has to be issued specifically for that motion to adjudicate in order to be, so really it's a jurisdictional thing, which is why in our initial housekeeping, I stated that the motion to adjudicate had been filed timely and the warrant had issued timely as well. And so I think that's what that part of the language of the statute means to reference. So let's talk about Garcia. And I agree with the state in that Garcia is a very good case for this court to look at, because Garcia does engage in that extra textual analysis. Granted, it's for a separate issue. It's in regards to whether the statutory scheme completely superseded the due diligence defense, because the statute as written only defines two separate instances where probationer can assert the right, failure to remain in place and failure to report. And so what the Garcia case looked at, what was on appeal, was whether or not in situations where a condition that was violated was something separate, was something different, failure to complete community service hours, whether in that context, the common law scheme survived. And the Garcia case found that it didn't after pursuing that extra textual analysis. But I want to draw attention to the court to Garcia on page 23. Because the state is correct. We don't have to guess how the court reads this language, because clearly they see they read the plain meaning into this. If you read the paragraph that begins with "this provision is more favorable to the state," it lays out three of the main purposes why this change was made. And the second purpose that the Garcia court points out is that, and I'm going to quote here, second, it limits the state's due diligence duty to contacting or attempting to contact the defendant at his last known residential or employment addresses, whereas common law required reasonable investigative efforts to apprehend the defendant. And so the way I read that is that the TCCA is saying that that making that attempt at that contact, that's the jumping off point for the court's discretion. And clearly they don't read any ambiguity in that, because they list that without analysis, just as a matter of course, a matter of the way they read it. And so again, I don't believe there's anything ambiguous about the language in the statute, but even if there is, I think the legislative history still supports it. And I brought this up in my initial time, because the language of the statute in its original form didn't require the attempt be made in person. It didn't require that. It was simply a phone call. It was simply a letter. And if you look at the April 24th, 2003 bill analysis for HB 1634, you can see that one of the concerns of the opponents of this bill was that it would make the threshold for due diligence too low, that simply placing a phone call and sending a letter was not sufficient. And they said in similar ways that a probationer shouldn't benefit from absconding, the state itself also shouldn't benefit. And I'll read directly from their analysis. The state should not benefit by doing nothing meaningful to locate a defendant or to execute a warrant. And so clearly when they added that language, the legislators clearly intended to raise the burden of the supervisory officer to meet that due diligence at a higher level than simply making a phone call or sending a letter. And so I believe that if the court does engage in that extra textual analysis, that even that will still support our position. Ultimately, again, I don't believe we get there, because as the Wheat case in Texarkana made clear, the sole issue here is whether or not that in-person contact was attempted. It wasn't. The probation file clearly documents, or rather doesn't document, that an attempt was made. And I think it is a fair inference for us to make that attempt never occurred. And on the very narrow issue of whether or not that happened, the answer is a resounding no. It didn't occur. And so I do believe that we met our burden of the affirmative defense by preponderance of the evidence. I want to respond also to the state, to Mr. Darnold's argument regarding the due diligence duty not necessarily falling on the district attorneys. The probation department in and of itself, they have the initial duty to make sure that these conditions are being met and to alert the trial court that the conditions aren't being met. And at that point in time, the state, they have the discretion as to whether or not to file the motion to adjudicate, the motion to revoke based off of that violation. And so once the state realizes and looks at that, I think the DA has an obligation there to go back and ask for documentation regarding what the supervision office did in regards to maintaining supervisory control. And so I don't believe that excuses their obligation. I certainly don't think that even if there was a level of that, I don't believe that any good faith attempt was ever attempted by anyone. And I don't believe that the state in this argument or the probation department should simply be able to throw their hands in the air and basically say, there's nothing we can do without actually trying to do something and failing at that. And so I think both the law, I think, supports our position. I think the facts support our position. And again, I just want to underline our analysis of this case being, number one, we don't believe that the trial court considered our argument of due diligence. Number two, we don't believe that even if she did consider it, we don't believe that she correctly applied the law to the facts. And then the third step is, even if there was a correct application, even if the state is excused from having to prove up the futility of their actions, even then, even with the actions that they did do, the 2 letters, the phone call, that clearly was insufficient under their obligation under the statute. And we believe that evidence that we met the burden in that manner as well. And so, justices, we would ask at this time that the court reverse the trial court's ruling. Again, if the court ruled on the first issue, I believe the remedy for that would be a remand. I don't think a remand is necessary in this case. Again, I do believe that all the facts are undisputed. I believe the court can do its own analysis regarding the application of the law to the facts. And so we would ask for a render at this point, and we would ask that the trial court's ruling be reversed. Thank you very much.
Thank you, counsel, for your excellent argument. Your case will be submitted on your briefs and the argument, and you shall hear from us.
Thank you very much.
Your Honor.
May I be excused, Your Honor?
You may.
Thank you, sir.